Hi, my name is Doug Small, and I'm here to talk with you today about getting ready for your deposition. A deposition is a part of the case which we call discovery. We have the initial beginning of the case, which is the filing of the complaint, and then the end of the case is where we have your trial, and the part in between, most of that is involved with discovery, which is the process of discovering or obtaining information about the case. One of the aspects to a discovery is a deposition. That's where you are asked questions by the other attorney about what occurred with your claim. Beyond that, we can also do depositions. We can ask questions and sit down with the other driver or the other parties involved with the incident that we're representing you about. And we can also acquire information by request for documents. We can depose witnesses. That's all part of the discovery process. Now your deposition. It usually takes about an hour to 2 hours to do a deposition. You shouldn't be afraid of it. You're going to do just fine. You're going to walk out of this conference room without any broken bones or anything like that. You're going to do just fine. In a deposition, the typical areas of questioning that occur are asking you some background questions about who you are, asking about the incident that led to your injuries, what your injuries are, your treatment, and then how you're doing today. Those are the basic categories. Your deposition will likely take place in our main conference room, which is where I'm at right now. We have a couple other conference rooms where it could take place at. In the deposition, we'll typically have a court reporter sitting here at the end. It's usually a lady. She has a little typewriter box that you've probably seen on TV shows with courtroom scenes. She'll be taking down what is said during the deposition. I usually have the other lawyer sitting right here. You'll be seated across in that chair, and either Ed or I will be seated in the chair next to you. So that's the setup. Again, it takes about an hour to 2 hours to do a deposition. And you're going to do just fine when we talk about it. Now let's talk about some details about the process. I now want to talk to you about the goals of a deposition. As I mentioned to you before, in a deposition, we're not in trial yet. It's a discovery part of the case, so it's a different scenario. In a deposition, the other attorney will be spending most of the time asking you questions. Ed and I will have maybe a few questions or perhaps even no questions in the deposition. It's a way, again, for them to acquire information as part of the case. So in doing that, we have three goals that we want to try to look for. First is we want you to tell the truth. We always tell the truth. The worst thing that can happen is we don't tell the truth, and you have no reason to do anything else but tell the truth. Second, we want you to be accurate in the testimony that you're providing. We don't want you to guess or speculate. We want you to be a good teller, an accurate teller of the information that's being stated. And then third, we want you to be a nice, polite, likable person. It's very important for that to happen. Because why? For three reasons. Well, for one primary reason, and that is that if that lawyer, the other side, leaves this conference room thinking that you're truthful, you're accurate, you can tell your story about what happened, and that you're a nice, likable person, they're going to be thinking that you're going to be very effective at trial, because a jury hearing you testify, and they're concluding that you're truthful, you're accurate, you know what happened, you're telling them what happened, and you're a nice person, a likable person, they're going to be much more inclined to give you a very favorable verdict at trial. So those are the goals that we have for a deposition. Now I want to talk to you about what I call the 4 golden rules for being deposed. You know, the good Lord took 10 rules in the 10 commandments, but I'm going to give you only 4 rules to do a good job in a deposition. So rule number 1 is, we've already talked about this briefly before, and that is telling the truth. It's always the most important thing. Again, you have no reason to do anything else but that, so we always tell the truth. So rule number 2 is to listen and understand the question. You're going to see or hear that all 4 of these golden rules are very, very simple. But to do them takes some effort. It takes some concentration on your part to do them well. In fact, I've had many people tell me that after they do a deposition, that they walk out of there feeling tired. It isn't tired because of physical exertion or anything like that. It's being tired like when you're in school, having taken a test, or in work where you have something you really got to concentrate on. It's that type of tiredness, because we want you to concentrate that much on what's going on in your deposition so you can do the best job possible. So going on to rule number 2, again, very simple, listen and understand the question. In doing that, take your time. We're not in a hurry, we're not in a rush. It's perfect when our clients, when they're asked a question, there's a slight pause between the time the question's asked and the time you begin to answer, because that means you've listened to the question, you're thinking about what the appropriate answer is. If you're asked a question, you don't understand it, you're unclear about it in any way. You know, as a lawyer, we don't always ask good questions. We can get our words all bollocksed up like anybody else can. If we are asked a question you don't understand, ask the other lawyer to restate it, and he or she has to do that. It's typical in a deposition of our clients that anywhere from a couple times to perhaps even a couple dozen times, they may ask the other lawyer to restate the question because they feel uncertain about it. Now, of course, if you understand it, we want you to answer it. There's no reason not to do that. But again, if you're troubled by it in any way, ask them to restate it. Also, it's important that when you listen and understand the question, that you let the lawyer get done talking before you speak. And again, the lawyer needs to do that for you. And if he doesn't do that, we'll be objecting to make sure that that's allowed. Because only one of you should be talking at a time. Because a court reporter who's sitting down here at the end of the table with their little typewriter box can only type down what one person is saying at a time. So take your time, listen and understand the question. One other thing before you go on is that it's a deposition. You don't do it every day. Chances are you've never done a deposition before in your life. So you're likely going to be nervous. And for me, that is a good thing. Because when you're nervous, that means you care. And if you care, that means you're going to be paying attention to what's going on. And your nervousness is a natural, instinctive reaction about doing something you're not familiar with. It goes back to our caveman or cavewoman days when they were in the forest or the woods and they hear a snapping of a twig and they don't know if it's a lion, a tiger, or a bear. And so they're nervous about that uncertainty. The same thing happens in a deposition. But when that happens, that means you're aware, you're more on top of things, you're attentive, you're paying more attention to what's going on in your environment, and you're going to be better reactive. It's a self-defense mechanism. So being a little bit nervous is a great thing. So don't feel bad about being nervous. You shouldn't be petrified because you're going to find out that a deposition really isn't that hard of a thing to do. All it is the other lawyer asking you questions about something you know more about than any other person in the world. So that's rule number 2, listen and understand the question. Rule number 3 is, next to telling the truth, is the most important rule, and that is to give a responsive answer. Generally speaking, your answers should be short and sweet and to the point. If you're asked a yes or no question, you should answer with a yes or no answer. You shouldn't feel like you have to go on to explain why your answer was yes or no. If you're asked where you live, a simple example, you should say, I live at 123 Main Street in Osceola, Indiana, and stop. You shouldn't go on to say that, well, I live there now, but before that I lived at 456 Elm Road in Mishawaka, and before that I lived at Schenectady, New York, because that wasn't the question. The question was only, and remember, you listen, you understand the question, and then what is the responsive answer to that question? Where do I live? I live at 123 Main Street in Osceola, Indiana, and that's your answer. Being responsive is very important because studies have shown that people who give responsive answers are much more accurate than people who are a talker. They go on and on and on. They become sloppy and they tend to make more mistakes than anybody that does just a short, sweet, and answer right to the point. And the other major point about giving a responsive answer, besides being accurate, is that your deposition will take a heck of a lot less time because you won't be talking as much. And believe me, if you're giving an answer and you're going on and on and on, it's going to lead the other lawyer to ask you questions about these other things that you've been talking about that chances are have nothing to do with your case. And it's just going to take longer and longer for your deposition to be done. So rule number 3, again, next to truth is the most important rule, is give short, responsive answers to the questions that are asked. And then lastly, rule number 4, is if you're asked a question you don't know the answer to, or you don't remember that information, just simply say that. I do not, and we do not, need you to be like an encyclopedia. We don't need you to have a perfect memory. I don't expect you to remember everything that was involved with your incident or your treatment or even what happened yesterday. So if you're asked a question you don't remember the answer, just say, I'm sorry, I don't remember. If you never knew the information, just say that. Don't guess or speculate. I could guess or speculate about the answer, but we don't need that. Remember, one of our goals is to be accurate. So you give accurate information about things you really know and remember. Now let's talk a little bit more about memory. It's kind of hard to quantify memory. But if you're more than 80% or you're less than 80% certain about something, I'd rather have you say, I don't remember. If you're almost certain, if you're at 90 to 95% certain about your answer, it's okay to give that answer, but I want you to qualify it by saying, I'm not quite certain, I think this is accurate, but I'm not quite certain, but I think, and then explain it. But if it's more than 90% not at 90% of certainty, then I'd rather have you say, I don't recall. Again, we want you to only talk about things you know and remember. So those 4 golden rules, they're very, very simple. But if you to do them well, it takes concentration. And that is to tell the truth, to listen and understand the question, to give responsive answers. And if you're asked a question, you don't know the information or you don't remember it, simply to say that. So they're very simple. Again, it takes concentration and focus to do that. But again, if you do those 4 things, you're going to do a great job in your deposition. Now I have one last general area of things to talk about, and we'll be done talking about preparation for your deposition. Now I want to talk with you about just some general and specific topics about getting ready for your deposition, and we'll be all done. First, a couple housekeeping things. First, arrival. It's good to come and arrive at your deposition about 15 minutes before the start time. I don't need you here a half hour early because you'll just be there twiddling your thumbs. And I'd rather you not be there just 5 minutes before because you'll be a bit of a tizzy, and it's better to have it a few minutes just to get yourself comfortable in being here. So 15 minutes is really good. Dress, nice casual attire is your order of the day. I don't need you to come in some tuxedo or a ball gown. I also don't want you to be here walking in just having come in from work and being all dirty and sloppy. So nice casual attire is just perfect. Now let's talk about some more things about specific questions you may be asked. It's not unlikely that the attorney will ask you what you did to prepare for the deposition. And it's totally appropriate for you to tell them what we're doing here. So you feel free to indicate that you met with me or with Ed in getting ready for your deposition, and that you may have looked at some documents, because they'll usually want to know what you looked at document-wise. And we're going to give you copies of your interrogatory answers. Those are the written questions that we put together with your assistants about the case. And we're going to have those there to review for you, just to go over. If we've done a settlement letter for you already, we'll give you a copy of that settlement letter, because that's a good summary about what happened and your treatment and all that type of information. So feel free to tell him that you've looked at those things in getting ready for your deposition. And you can tell them that we've met. I'm going to give you 2 other documents, or we'll give you 2 other documents, which are the golden rules I told you about, those 4 golden rules. There's another document I'm going to give you. It's the 87 rules of a deposition. You're going to say 87 rules. And when I first saw that, I go, you got to be kidding me. But I give that to you because after reading it, it gives you a good idea, approach that we want you to take in doing that deposition. But those documents, those are really attorney-client type of documents where we're giving you our thoughts about what you should be doing. So you don't need to identify those in your case preparation. But the factual things that we're going to give you, again, any discovery responses, those written questions, and the fact that we reviewed a settlement letter, assuming we've got one done for you, you tell them about that. Now, in doing a deposition, it's about facts. You hired us to be your lawyers. We're the ones that need to be arguing your case. We do not want you to argue your case. In your deposition, we only want you to give the facts about what happened. I don't want you to give your opinions. I don't want you to be argumentative. I want you to be a nice, polite person. In fact, I want you to approach this, if you're a church-going person at all, if you've ever gone to church in your life, or whatever it is you do religious-wise, I want you to imagine you're talking to your pastor, your priest, your rabbi, your guru, whoever it is. You're not going to be argumentative to them. You're not going to be trying to convince them. You're not going to be acting towards them like a politician. You're going to be nice, polite, respectful, giving them the actual information that's involved. And that's the same type of approach we want you to take in answering your questions in the deposition. So again, just facts. So for example, if it's a speed case involving an auto accident, and you're asked how fast a car was going, I'd want you to say the car was going about, whatever it was, 75 miles an hour. I wouldn't want you to say that that car was going like a bat out of hell, all right? You give them the factual information. You don't give them opinions about what happened. One other thing about talking about the lawyer, most lawyers are okay. They're not going to be difficult with you and irrational or unkind or mean, but some can be. If that happens, we're going to be there to deal with that for you. But sometimes even a respectful lawyer can ask a question that can get under your nerves. It's not, sometimes it happens, a lawyer says, well, Ms. Smith, you don't mean to expect me to believe that this happened this way. And by the very nature of that question, it's implying that you are not being truthful about what happened. I don't want you to get mad about that. Again, I want you to treat that person in a nice, polite, respectful way. Just say, I'm sorry, sir, I'm sorry, ma'am. That's what happened. The car was going 75 miles per hour. and don't argue at all, just to give them the factual information. Note-taking, we don't want you to take notes. We just want you to walk in there with the clothes you're wearing, because if you take notes, all that's going to do is lead the other lawyer to ask you questions about what you're taking notes about. Your deposition is going to take longer. Exhibits, there may be exhibits, photographs, that type of thing. If there's a document, you may have you look at that, and I want you to do that. I encourage you to do that, to look at that to help you refresh your recollection if there is reference to exhibit. If you want to look at it, you just simply say, I'd like to look at that, and you have every right to look at that exhibit. Another thing I want to talk to you about, especially in some of these points I'm talking about, don't apply to every case. This is dealing with an automobile accident case that I'm going to talk to you about right now. And those are questions involving speed, time, and distance. That's an equation. If I know any two of those variables, I can figure out the third. So for example, if you were to tell me that to get to our office today, it took you an hour and you were traveling at 55 miles an hour, your average speed the entire way here, that I would know that you lived 55 miles away from our office. Because if you know any two of those equations, I can figure out the third. And that's even if it's a fractional. If you told me that you traveled 22.5 minutes to get here, and your average speed was 37.7 miles an hour, I could figure out the exact equation to figure out what your distance was from where we were at. So it's very precise. It's a mathematical thing. And the thing that becomes a difficulty in an auto case is that those are very emotional times, and things happen so fast, and perceptions can be so wrong. In addition, when you're traveling 55 miles an hour, you're going 88 feet a second. That's a third of the length of a football field when you go 1,001 that you've gone. We don't appreciate how fast and how far we're going when we're going at these speeds. I had a case once where a lady testified in answers to me about speed, time, and distance. And when I did the calculations, for it to work out the way she testified, she would have had to have been going 240 miles an hour, which wasn't the case. So because of those dangers, I prefer, unless you have a specific objective point of reference to know, especially about time and distance, for you to say we were very close and it happened very quickly. Because otherwise, anything you say is going to be probably a complete guess. And it's not a fabrication, but it's going to be inaccurate. So be very careful about speed, time, and distance. With speed, we're usually better at that because we've been driving or we've been in cars as passengers for all of our lives, that we have a fairly good idea about speed. So I don't have a problem with you talking about speed, but talk to it about a general range and not about a specific area. Like, for example, I think the car was going 30 to 35 miles an hour. And then stick with that. Don't let the other lawyer try to say, well, could he have been going 36, could he have been going 37. Stick with what your thought was. So if you think the car was going between 30 and 35, say that, but then stay with it. Don't vary from that. When it comes to distance, and especially time and distance, you're much better off just saying it was very close, it happened very fast, and you're trying to get into specifics because you'll likely be wrong. Now I'm going to change the subject again. I want to talk to you about pain. Typically, lawyers will ask you, in the course of a deposition, to rate your pain on a 1 to 10 scale. We do that because in hospitals, if you've been in a hospital, they got a little chart on the wall that has you talk about pain on a 1 to 10 scale, and the nurses will often come in and ask you about that. With 0 being no pain, 10 being your worst pain. You've got to, again, going back to our 4 golden rules, rule number 1, we are always truthful. I want you to be truthful. So I don't want you to exaggerate your pain. I don't want you to be a whiner, because nobody likes a whiner. I also don't want you to be like a Clint Eastwood type that you just got shot in the arm and they ask you if you're hurt and you say, nah, I'm okay. Neither of those are truthful answers. I want you to be truthful, so I want you to objectively say what your pain was like. And then when it comes to that 1 to 10 scale, 10 is the worst pain you've ever had in your life. And this crash or this incident that took place with your injury, you may not have been at your worst pain. If that's the case, then you should say what it was. It was a 7 or 8 or a 9. If it was a 10, then you should say it's a 10. On the other end of the spectrum, everyday life we have some pain. You could wake up because you slept wrong, you got a crook in your neck, and that's a 1 or maybe a 2. In an accident, your pain's going to be different than that. So for an accident pain, typically that's going to be at least a 2, if not a 3, because it's not everyday pain. and then it's going to be maybe up to a 10. But whatever it is, it is. And we don't want you to understate it. We don't want you to overstate it. Just tell it like it really is, if you're still having difficulties today, or like it was, because chances are your pain has changed over the course of time. Speaking about that, if your pain was a 10 after the crash, it wouldn't have stayed a 10 to today. It would have gotten better. And typically we get better in a downward scale. Your worst pain is up here, and you gradually get better to where you are today. And you should reflect that in your answers about how that has happened and what your pain has been like. In doing that, though, we go back to rule number 3. We only provide that information in response to a question that you're asked. So if you're not asked about this information about how your pain changed, what it was on a 1 to 10 scale, I don't want you to volunteer that information. We only answer the questions that are asked, okay? That is so important. Truth and just giving responsive answers. So that is my view about the 1 to 10 pain scale. One other thing I want to talk to you about pain, and we're nearly done with this discussion, and that is, and I want you to think about this, and it's also helpful sometimes to write these things down, because when we write things down, it clarifies our thoughts and thinking. It helps us with remembering different things. So, and that is what we call the descriptors of pain. And I want you to think about this. First descriptor is type. And again, I'm going to give you some notes that's going to talk about all these things, so you don't need to remember all the things I'm talking about here. But type of pain, is it achy, sharp, burning? What is your pain? Was it what it was like? And that may have changed over the course of time since you've had your injury. Next is frequency. At the beginning, your pain may have been constant. You never got away from that. But then it gradually got better where it became periodic. So when it did become periodic, what has been that frequency? And that frequency may have changed over time. So it's good to think about that so you're better prepared to answer those questions should they come. Next is triggers. When your pain does become periodic, are there certain things that trigger it? That can be activity. It can be weather changes. Many people tell us that if they have an injury, when you have a weather front comes through, it'll trigger pain symptoms. Certain positions that you put your body in can trigger pain, but to think about what are the triggers of your pain. Next is duration. When you do have pain symptoms, how long do they last, typically? And then lastly, relief. What can you do to make yourself better? That could be just resting, it can be taking some pain medications, it can be getting a massage, whatever it might be, it gives you relief from your pain. So I'd like you to think about those things so that when the other attorney asks you the questions, you can give a more informative, thoughtful response and not wish later, geez, I wish I'd have known that was coming and I would have told him this. So I want you to think about those things in advance. And with that, most attorneys, and when I do these depositions from the defense side, ask a question like this. What are the things today that you can no longer do or that you can still do, but not do it as well or not without complications because of your injuries? So it's good to write down, again, on a piece of paper, at least 5 things, maybe even up to 10 things, in 3 areas of your life. There's 3 basic areas we have in our lives. Our social, fun part of our lives, our work part of our lives, which hopefully is not as fun too, and then third, family type of activities. So I'd like you to think about, in your daily lives, the effect of your injuries, what things have been affected by those injuries. Dealing with your kids or your grandkids. Athletically or activity-wise, that you can't jog anymore, or you can't go bowling, or you can't throw horseshoes or ride a bicycle, whatever that might be. And what your work may have changed with restrictions and things like that. So it's good on a piece of paper to write down 2 or 3 things in each of those 3 areas of your life that have been affected, so that when you're asked those questions, you're better able to give a response. Now, the one last thing I want to talk about, and we're almost done here, is that especially if it's been your case involves an incident. It could have been a slip and fall scenario, it could have been an auto accident, it could have been a construction accident. If you have the opportunity, we always like you to go back to the scene, if you can, a few days before your deposition, just because there'll be this, you think you remember things and you don't. Was there a light post here? Where was the stair at compared to a doorway entry? If you have the opportunity to go back to the accident scene and just spend a few minutes just looking around, it's always a good thing to do. Again, I don't need to worry about memorizing things. I don't want you to take a tape measure out and measure things. It just is a good refresher for your recollection about what happened. So those are the last things I have to talk to you about in getting ready for your deposition. There's one last thing I want to tell you. Well, I appreciate your attention in getting ready for your deposition. You're going to do a great job. In just a few minutes, either Ed or I is going to come in and meet with you just to go over and talk about the specifics of your case so that we're fully prepared for your deposition. But again, thank you for your attention. And when I said you're going to do a great job, I really mean that. I tell you, if you listen to the question, keep your answers responsive. If you don't know, don't remember, say that. And of course, always tell the truth. You're going to do a wonderful job in your preparation for your case. Thanks.